How about a white pill? Everybody loves a good white pill. Supreme Court of the United States. Caniglia v. Stramail. Cert. The United States Court of Appeals for the First Circuit. Argued March 24, 2021. Decided May 17th, yesterday. During an argument with his wife, petitioner Edward Canigula placed a handgun on the dining table and asked his wife to shoot him and get it over with, end quote. His wife instead left the home and spent the night at a hotel. The next morning, she was unable to reach her husband by phone, so she called the police to request a welfare check. The responding officers accompanied Canigula's wife to the home, where they encountered Canigula on the porch. I'm not saying his name right at all. I apologize, but let's continue. The officers called an ambulance based on the belief that he posed a risk to himself or others. Canigula agreed to go to the hospital for a psychiatric evaluation on the condition that the officers not confiscate his firearms. But once Canigula left, the officers located and seized his weapons. So they stole from him. Great. Canigula sued, claiming the officers had entered his home and seized his firearms without a warrant in violation of the Fourth Amendment. The district court granted summary judgment to the officers. So the district court said the officers did right. The First Circuit Court affirmed. So they appealed for it, and they lost appeal, which that was probably a downer for them. So they appealed to the Supreme Court, baby. Good for them. Extrapolating the court's decision in Cady versus Dombrowski, a theory that the officer's removal of Canigula and his firearm from his house was justified by a community caretaker exception to the warrant requirement, held. Neither the holding nor the logic of Cady justifies warrantless searches and seizures in the home. Cady held that a warrantless search of an impounded vehicle for an unsecured firearm did not violate the Fourth Amendment. Okay, guys, think about that, though. That different set of facts completely here. Impounded vehicle is when the vehicle is in possession of the police. So if there was a gun inside a impounded car and somebody broke into the impounded lot and then got a hold of the gun and did some crimes with it, it would kind of be partly the police's fault. That's where he got the gun from the car that was in police's custody. So they are going to search the car that's in their custody for any illegal stuff too. But searching somebody's house, the home is sacred. In reaching this conclusion, the court noted that the officers who patrol the public highways are often called to discharge non-criminal, quote, community caretaking functions, end quote, such as responding to disabled vehicles or investigating accidents. But searches of vehicles and homes are constitutionally different, as the Cady opinion repeatedly stressed. So this was an opinion. They said, hey, this is different, but the First Circuit ignored it. The very core of the Fourth Amendment guarantee is the right of a person to retreat into his or her home and therefore be free from unreasonable government intrusion. A recognition and exercise of community caretaking tasks, like rendering aid to a motorist in disabled vehicles, is not an open-ended license to perform them anywhere. Vacated and remanded. Thomas delivered the opinion of unanimous court. Everyone agreed. It's pretty short. There you go. Can I just read this part? Oh yes, this is the different. The opinion of the court. Here we go. The opinion's the good part. It's all the good part. It's a fucking great opinion. All 9 of justices agreed that they shouldn't have fucking gone into somebody's house to take their guns because he was acting a little wonky. Decades ago, this court held that a warrantless search of an impounded vehicle for unsecured firearm did not violate the Fourth Amendment right. In reaching this conclusion, the court observed that police officers who patrol the public highways often called to discharge non-criminal community caretaking functions, such as responding to disabled vehicles and investigating accidents. The question today is whether Katie's acknowledgement of these caretaking duties creates a standalone doctrine that justifies warrantless searches and seizures in the home. It does not. Yeah, cops just can't break into your house, take your shit for your protection, because, you were saying a little you said some scary stuff on Twitter. You said you were feeling really depressed today. So we're going to have to take away that firearm. During an argument with his wife at the Rhode Island home, we know the facts already. Petitioner sued. We read that part already, according to the First Circuit. Accordingly, the First Circuit saw no need to consider whether anyone had consented to the respondent's actions. Okay, we're going to back up a little bit here. Petitioner sued, claiming that respondents violated the Fourth Amendment when they entered his home and seized his firearms without a warrant. The district court granted summary judgment to the respondents, and the First Circuit affirmed solely on the grounds that the decision to remove petitioner and his firearms from the premise fell within the community caretaking exception to the warrant requirement. This community caretaking exemption, they really wanted to stretch that wide open, didn't they? In the First Circuit, they thought that cops could break into your house and steal your guns for your protection. That's amazing. I'm glad the Supreme Court shut them down. Citing the court's statement in Katie that police often have non-criminal reasons to interact with motorists on the public highways. Yeah, oh great. Public highways means we can go inside your house. The First Circuit extrapolated a freestanding community caretaking exception that applies to both cars and homes. Threats to an individual and community safety are not confined to the highways. Accordingly, the First Circuit saw no need to consider whether anyone had consented to the respondent's actions, whether these actions were justified by exigent circumstances, or whether any state law permitted this kind of mental health intervention. All that mattered was the respondent's efforts to protect petitioner and those around him were, quote, distinct from the normal work of criminal investigation, end quote, and fell, quote, within the realm of reason, end quote, and generally tracked what the court viewed to be sound police procedure. Regrant certiorari. So the First Circuit was saying all that mattered that the police were trying to protect him and those around him. And that's within their line of criminal duty. That's what police do. And this guy was a threat to himself. So we get to break into your house. The Fourth Amendment protects the right of the people to be secure in their persons, houses, papers, effects against unreasonable searches and seizures. The very core of this argument is that the right of a man to retreat into his own home and therefore be free from resources or government intrusion. Florida v. Jardine. To be sure, the Fourth Amendment does not prohibit all unwelcome intrusions on private property, only unreasonable ones that have thus recognized a few permissible invasions of the home and its curtilage. Perhaps the most familiar, for example, are searches and seizures pursuant to a warrant. Collins v. Virginia. We've also held that law enforcement officers may enter private property without a warrant when certain exigent circumstances exist, including the need to render emergency assistance to an injured occupant or to protect an occupant from imminent injury, or if hot pursuit too. The First Circuit's based prism, I don't know what that is. The First Circuit's community caretaking rule, however, goes beyond anything the court has recognized. The decision below assumed that respondents lacked a warrant or consent and expressly disclaimed the possibility that they were reacting to a crime. The court also declined to consider whether any recognized exigent circumstances were present because the respondents had forfeited the point. So the police didn't even say that there were exigent circumstances. They didn't even bother to argue that. They said, no, we're allowed to do this. Or, someone says, shoot me, and they have a gun, that means you're allowed to take their gun. That's what these police thought. If you have a weapon and you ask your wife to shoot you with it, the police can now go into your house and take your gun. That's what the First Circuit thought. Nor did it find that respondents' actions were akin to what a private citizen might have had the authority to do if petitioner's wife had approached a neighbor for assistance instead of police. So, for example, the community caretaking example is the police can do stuff similar to what a neighbor could do. So, for example, a neighbor could help render assistance to a motorist on the side of the road. You see it all the time, motorists helping other motorists. And that's what the police can do too if they want to. Or they could arrest you for having a taillight out, anyways, or ticket you. So if the petitioner's wife had approached a neighbor instead of the police, none of this would have happened. Neither the holding nor the logic of Katie justified the approach. True, Katie involved a warrantless search for a firearm, but the location of the search was an impounded vehicle, not a home. A constitutional difference that an opinion repeatedly stressed. In fact, Katie expressly contrasts the treatment of vehicle already under police control with a search of a car in a parking lot adjacent to a dwelling place of an owner. So they were saying, I mean, you probably can't even search that car. So I don't know how they expanded Katie to be, you can go inside your house. Katie's unmistakable distinction between vehicles and homes also places in the proper context its reference to community caretaking. This quote comes from a portion of the opinion explaining that the frequency of which vehicles can become disabled and involved in accidents on public overways often requires police to perform non-criminal community caretaking functions, such as providing aid to motorists. But this recognition that police often perform many civic tasks in modern society is just that, a recognition that these tasks exist and are not an open-ended license to perform them anywhere. What is reasonable for vehicles is different from what is reasonable for homes. Katie acknowledges much that, and this court has repeatedly declined to expand the scope of the exception of the warrant requirement to permit warrantless entries in the home. Collins. Thus, we vacate the judgment below and remand for further proceedings consistent with this opinion. It is so ordered. Whew. All right, that's the important decision. There's other little bitch-ass decisions on here from Roberts and Alito. These guys wanted to talk about the red flag bullshit some more. Nah. Red flag logs are bullshit too. They should straight up say red flag laws are unconstitutional too. That's what they should have done. That'd be hilarious. And if you guys like this type of content, leave a like down below, subscribe, share with your friends. Radically Moderate here.